Bonjour et bienvenue dans notre cours y sus excelencias, distinguidas señoras y señores, buenos días y bienvenidos en nuestra corte. I warmly welcome you all to this wonderful occasion today, the installation of the third President of the Caribbean Court of Justice, the Honourable Mr. Justice Adrian D. Saunders, or perhaps one should say the Adrian Saunders. However, I venture to posit that while the CCJ is gaining relevance, the Privy Council seems to be somewhat in decline. This year, up to now, the court, the CCJ, with only 4 small Caribbean jurisdictions, delivered about the same number of judgments as the Privy Council, with 31 jurisdictions. While the court delivered 21 judgments, this court, 21 judgments with a few more to come this month, the Privy Council delivered 11 judgments in the Caribbean cases. 6 from Trinidad and Tobago, 2 from Jamaica, 2 from Cayman Islands, and 1 from Antigua and Barbuda.
The CCJ aims at being, and I quote, innovative, fostering jurisprudence that is reflective of our history, values, and traditions, and consistent with international legal norms, end of quote. This jurisprudence, one would imagine, is one to which all Caribbean community states will eventually subscribe, having given concrete evidence of their disposition to adhere to it by their prior accession to the appellate jurisdiction of the court. To be realistic, however, we are all aware of the degree to which we in the region, and Trinidad and Tobago in particular, adhere to the ancient Roman dictum, festina lente, hasten slowly.
In a sense, the failure of the other Caribbean countries, other than the 4 of us, Barbados, Belize, Guyana, and Dominica, to accede to the appellate jurisdiction of the CCJ is akin to giving birth to a child who continues to grow and continues to pretend to be independent, but still be umbilically tied to her or his mother.
His Honor, being a graduate of 2 regional institutions, as you would have heard earlier, the University of West Indies and the law school set up by the Council of Legal Education, is familiar with the culture, the collective history, the diversities, the laws, the nuances, and the various institutions of the Caribbean. He would, I would say, feel the pulse and understand the heartbeat of the people of this region.
We are reminded that on February the 14th, 2001, the agreement establishing the CCJ was signed by Antigua and Barbuda, Barbados, Belize, Grenada, Guyana, Jamaica, St. Kitts and Nevis, St. Lucia, Suriname, and Trinidad and Tobago, to be followed by Dominica and St. Vincent and the Grenadines. Altogether, 12 signatories. On April the 16th, 2005, the CCJ was inaugurated at a ceremony in Port of Spain, right here in Port of Spain. Trinidad and Tobago proudly remains the home of the CCJ. This institution that continues to make bold strides for its age in the dispensation of justice.
The founders of the Faculty of Law, University of the West Indies, linked the establishment of the CCJ and the faculty as crowning the legal architecture of the region. It was felt that the faculty would nourish the jurisprudence of the CCJ. In turn, the CCJ would set a new agenda for legal research and development, sensitive to the legal imperatives of the development of our region. It would fashion and administer accessible, affordable justice that could produce real change for CARICOM peoples. The CCJ has not disappointed. To date, has issued judgments of far-reaching implications which has touched the life of every citizen. Who has not heard that David and Goliath story of the little Jamaican girl who tried to enter Barbados, was strip-searched and successfully sued that illustrious state? In these judgments, our new president has played a seminal role, well prepared, having served on the Eastern Caribbean Supreme Court in different capacities.
I must just mention two things, and one is his dedicated work as a judicial educator. He is an acclaimed, internationally sought after and acclaimed judicial educator. He is a pillar of the Commonwealth Judicial Education Institute. We wouldn't exist without him. And he has realized the dream of so many of us of a regional judicial education body by his establishment and maintenance, if I may say, of CAJO.
You follow in the footsteps of two giants of Caribbean jurisprudence who have secured their place in the pantheon of world-renowned jurists. I have every confidence that you will fit comfortably into their shoes. You have been an integral part of this court since its inception. Contrary to the warnings of the naysayers, this court has not been the instrument of the heads of government of the region. In the British Caribbean Limited case, Your Honor, you said this: the rights and freedoms of the citizens and democracy itself would be imperiled if courts permitted the executive to assume unto itself essential lawmaking functions in the absence of constitutional or legislative authority to do so. In young states, especially, keen observance by the courts of the separation of powers principle remains vital to maintaining the checks and balances that guarantee the rule of law and democratic governance.
This court was able to quickly convene on a Sunday for a full hearing after receiving documents filed just 2 days prior on a matter of great urgency. The history of that matter is that the general elections in Barbados were scheduled to be held 2 weeks from the date of that hearing, and Commonwealth nationals resident in Barbados who satisfy the eligibility requirements for registration to vote in those elections, as prescribed by statute, were being denied that right by an arbitrary ultra-vires policy, which had no basis in law, and the court so found. The CCJ's existence and continued growth and development is evidence that these Caribbean nations hold dear these fundamental human rights to access to justice and the critical role of the rule of law in any democracy, and have made every effort to uphold that right by facilitating access to fair justice by a wider number of its constituents for a greater range of matters. We are confident in and comforted by the stewardship of our court, and we are assured beyond any doubt that we will continue under your leadership to be guided with steadfast determination and tempered velocity towards our destiny.
A long time ago, Bertrand Russell wrote about people for whom the past is vivid and the future illuminated by knowledge of the slow and painful achievements of former times. This remarkable book, The Caribbean Court of Justice, the first 10 years, which everybody in court should get a copy of before they leave here, reflects and shows us how long it took and how hard it was for us to get here where we are today. And today, we start a new generation. Today, this court, our Barbadian, Belizean, Dominican, and Guyanese court, is led by our new president, Your Honor Justice Saunders, who learned his law right here in the Caribbean, in Barbados and Trinidad, the same as most of us lawyers and judges here today, along with 4 of the 6 judges sitting in the Caribbean Court of Justice, with Your Honor.
Adrian has been a very close friend of mine for more than 50 years, dating back to our first year at the St. Vincent Boys Grammar School. There are about 8 other such mutual friends, a phenomenon that I truly cherish. We are all exceedingly proud and joyful to celebrate Adrian's elevation to the presidency of the Caribbean Court of Justice. The longevity of our friendship places me in the advantageous position of knowing, understanding Adrian's amazing journey. He had a most wholesome family life. Wonderful, caring, loving parents in Thomas and Auntie Theo Saunders. We spent many nights in the basement of their home. And 4 elder siblings, all exemplary human beings.
The successes of the CCJ are too numerous to describe in my short presentation. However, as a scholar who studies intently the original jurisprudence of the court and some areas of the appellate jurisprudence, I am pleased to note that the Honourable President has been on the judicial panel for many of the court's most profound and innovative judgments. With respect to the original jurisprudence, the court has substantially developed, some might say transformed, Caribbean community law. The CCJ has converted the leaden substance of the revised Treaty of Chaguaramas into a golden Magna Carta for the peoples of the region. A treaty between states, creating rights and obligations for states and the Caribbean community, has been transformed by the CCJ's judgment in Trinidad Cement and Guyana into a treaty creating rights for persons, both juridical and natural. In addition to the revised treaty, these rights have been held to arise from decisions of CARICOM organs, as most famously illustrated in the case of Shanique Myrie and Barbados. As a result, persons may bring legal challenges based upon rights derived from the treaty, from decisions of community organs, and at least potentially from general principles of law, community law and international law.
Colleagues, distinguished guests, I don't know what one says after such encomiums. I vividly recall that August afternoon when I was invited to become a judge of the Eastern Caribbean Supreme Court. It marked the beginning of a defining chapter in my life. That chapter has now spanned 2 decades, and throughout that time I've had this extraordinary honor to play a role not just in resolving disputes that people bring before the courts, but more importantly, to be a part of the building and refinement of everything that accompanies the creation of jurisprudence. The opportunity to participate in the social progress of the region in this way is a source of immense pride and satisfaction. And to be afforded now the distinction of serving as President of the Caribbean Court of Justice is a responsibility that I can only describe as humbling. As has been said, I've been preceded in this office by 2 outstanding Caribbean jurists, Justice De Labastide and Sir Dennis Byron, each in his own unique way, has made a towering contribution to the solid platform on which the court now rests. And I'm extremely pleased, and I thank you for both gracing us with your presence this morning. Having been privileged to have enjoyed a close collegial relationship with each of these titans when they were president, and certainly in the case of Sir Dennis, even before he was president of the court, I can say without reservation that I feel I am well prepared for the task ahead. Since its inception, the court has been steadily seeking to advance for the people of the region their democratic values, protecting individual rights, promoting the rule of law, and of course interpreting and applying both the revised Treaty of Chaguaramas and other domestic laws. The court, in other words, has been fulfilling its purpose of developing our Caribbean jurisprudence. And the court has been doing this with a first-rate complement of judges and an efficient court staff that frankly enable us to perform amazing feats. Ms. Weeks mentioned the events 2 months ago. Who will forget? The 11th of May, 2018, at about 5 o'clock in the afternoon, it was a Friday afternoon, our registry staff received for filing from Barbados an appeal record containing some 507 pages. The appeal that was submitted was extremely important. It had to do with the vindication of a right denied most Caribbean people for centuries, the right to vote. The appeal was also urgent because the elections in which the litigant desired to vote was mere days away from being held. Within minutes, the documents were filed and returned to council and then emailed to the judges of the court. With the cooperation of the Chief Justice of Barbados, Sir Marston, a courtroom in that country was set aside for a hearing by video conference at 11 a.m. on that Sunday. At least one of the CCJ judges hearing the appeal was not at his home that Friday evening when his mobile telephone alerted him that an appeal record had been filed and emailed to him. Given the urgency of the matter, he opted to read and study the documents on his phone. The appeal was fully heard and scheduled on that Sunday, and the court was able to give a decision at 2:30 p.m. that same day, less than 48 hours after the appeal had been submitted for filing. Now, I recount the above facts in some detail so as to highlight the technological capabilities of the court, the dedication of its judges, the efficiency of its court staff, and the overall effectiveness of the court's appeal processes. Both in the original and in the appellate jurisdictions, this court has expanded access to justice. I like to think of the law as a huge overarching tapestry of rules and regulations and court judgments that governs every facet of our lives, constraining our choices and shaping our everyday actions. And this tapestry has many creases and corners and crevices that are obscure. And the only way that some of these obscurities will come to light and be unraveled is when a dispute emerges that touches on them. If access to justice is impeded, these corners and crevices remain obscure. The CCJ helps to shine a light on these obscurities. Many more of them are now able to come before the court for suitable decisions to be made. The comparison of the volume of cases heard from Belize before and after that country joined the appellate jurisdiction of the court in 2010 shows a dramatic increase. The comparable figures for Barbados are even more astonishing. For this year alone, we have heard 7 times as many cases as were dealt with in 1 year by that country's final court before they began sending appeals to the CCJ. And we're particularly proud that the level of this access today extends to so many who would never have before been able to have final appeals to an apex court heard. As one speaker explained before, I think it was Ms. Weeks, the countries of, or Mr. Mamkaran, the countries of Barbados, Guyana, Belize, and Dominica are truly to be saluted. They have completed the circle of their independence. They have made a conscious choice to sever the final vestige of the colonial chain. They have achieved a higher level of self-determination than their sister states, and correspondingly, their people enjoy a greater degree of access to justice at the apex court level. The Regional Judicial and Legal Services Commission, the RJLSC, and the CCJ's Trust Fund are the twin pillars that support the Caribbean Court of Justice. These are bodies that are independent of governmental control. They are run by Caribbean men and women who are experts in a wide variety of disciplines and who volunteer freely their time and expertise. The Trust Fund guarantees that appropriate finances are available to meet the court's expenses. The Commission, among its many responsibilities, ensures that the court is staffed by high-quality judges and efficient administrative officers. The President of the court, by virtue of his or her office, is the chair of the commission. Yesterday, for the first time, I had the privilege of chairing a regular meeting of the commission. And I was immediately struck by the range and complexity of the matters with which the commission grapples. And it would be remiss of me if I did not use this opportunity to express my deep gratitude to the members, both those past and those presently serving, of the commission and the trust fund. Because we had that meeting yesterday, I think all the members of the trust fund are here with us today, and I ask you to give them a round of applause. Commission, sorry. Your noble and selfless service, your deep commitment to the enrichment of our Caribbean civilization are deeply appreciated by all of us at the court. I wish also to thank all the speakers this morning for your warm words of congratulations, of support, of encouragement. I will be forever be inspired by them. Among the dignitaries, colleagues, and friends present, some of you have traveled from near, some from very far. The effort you have all made to be here to celebrate this occasion with me and with the court is sincerely appreciated, and I thank you so much for that effort. I think of myself as having 3 families, and I'm deeply indebted to each of them and wish to express to each of them my deepest gratitude. In my first address to the court, I referred to my colleagues and the staff here as one big CCJ family. The love and warmth, enthusiasm I have seen and experienced this past week from this family has been so overwhelming, sometimes it left me speechless. Then there's a family that comprises the Caribbean Association of Judicial Officers, or CAJO. This family that has gone to tremendous lengths to organize the fundraising gala this evening in my honor. The proceeds of that event will support the several programs CAJO organizes to improve the quality of judges in the region. I hope it is not too late for those of you who have not yet bought tickets to be able to do so. But in any event, I thank you, CAJO, for this great gesture. And of course, there's my natural family, my wife and other family members, many of whom are here, from which I draw deepest sustenance. To them, I also express all my thanks, my gratitude for the constancy of your support. Like the day that launched me on this chapter of my life, today too is a day I will always remember. And I thank you all for making it such a special one for me. Thank you.